Hello, everyone, and welcome to the next episode of Sorainen Arbitration Series. My name is Elvis, and I'm an associate with Sorainen Latvia. Today, together with my colleague Maria from Sorainen Belarus, we are filming our next interview, where we will get exclusive insight into work of Finland Arbitration Institute. Finland Arbitration Institute is one of the arbitration institutions which considers Baltics and Belarus as their target markets. Also, what is unique, Finland Arbitration Institute is actually one of the oldest functioning arbitration institutions in the world, turning 110 next year. That's why today we are very pleased to introduce Santtu Turunen, Secretary General of Finland Arbitration Institute. Santtu, hello, it's nice to see you.
Good morning, Elvis. Good morning, Maria. Nice to see you, and thank you very much for the invitation to the series.
Santtu, pleased to meet you, and it's our honor to be entrusted with interviewing you. To begin with, you're well known as an active member of the arbitration community. Thus, could we start with kind of a personal question and ask you what brought you to become the Secretary General of the Finland Arbitration Institute?
My path to arbitration was through research and teaching initially. I started by writing an article on independence and impartiality of arbitrators and realized what an interesting field of law arbitration is. I kept doing research and teaching at the University of Helsinki and eventually started coaching the Helsinki Vismut team. I got in touch with the arbitration community and met many wonderful friends and colleagues around the world. Also, I started acting as an arbitrator and really liked the practical side of the business too. The more experience I got, the more rewarding it all became. So eventually, now I feel that the FAI is a chance to learn about arbitration and contribute to the community from yet another perspective.
Okay, Santtu, let's heat it up a little bit with a provocative question. Why to choose institutional instead of ad hoc arbitration?
Actually, I don't consider the question provocative at all. We all have to be able to explain what added value we offer for our customers. And what the institutes bring to the table in comparison to ad hoc is speed, cost efficiency, predictability, and outcome quality. We have rules that offer a framework for the procedure and increase predictability. We control the duration of the procedure, and we set the arbitrator's fees according to the rules. We as an institute are also a repeat player on the arbitrator market and thus have leverage on quality, which we monitor carefully. Having said this, the FAI may also appoint arbitrators in ad hoc cases if the parties so agree. Also, the FAI may serve as an appointing authority under the ancestral arbitration rules.
A personal thanks from me for such an outstanding overview of the benefits of institutional arbitration. And I will definitely quote you next time I will have to explain the difference to my clients. Now, having made use of this opportunity, Santtu, can you please name advantages of Finland Arbitration Institute, which you consider most significant and most attractive?
The three competitive advantages I would like to bring up are expeditiousness, the professional board and secretariat, and finally the Finland-related selling point, which make it easy to trust the Finnish service provider. Firstly, we are very expeditious and efficient. The median duration of the regular FAI arbitration is 8 to 9 months after the transmission of the case file to the tribunal, and approximately 11 to 12 months in total from the request for arbitration to the final award. The expedited arbitrations are even faster, with median duration of 3 months after the transmission of the case file and a bit more than 5 months in total. Secondly, we have a very professional, experienced and international board and a dynamic secretariat which work very well together. I understand that this sounds like something that any institute would say, but I'm sure that our users can confirm my message. This translates not only to short median durations, but also to good decisions in terms of arbitrators and costs. All in all, we have a solid Nordic and pragmatic no-nonsense approach to administering arbitrations. Thirdly, Finland is one of the least corrupt countries in the world. According to the Global Competitiveness Report of the World Economic Forum, Finland ranks first in factors such as judicial independence, efficiency of legal framework in challenging regulations, security, property rights, and intellectual property rights. This, of course, primarily sells Finland as a seat of arbitration, but I believe this also makes it easy for the parties to trust the Finnish service provider on judicial market. We have modern rules that reflect the best international practices, and we are competitively priced, but I believe these are just starting points and necessary prerequisites, not really selling points in comparison to other internationally recognized institutes.
Santtu, indeed, these are usually the things that clients are considering when actually choosing the right institution. Let's continue with the most discussed topic worldwide this year, which is COVID-19 and changes related to it. In the times of COVID-19, do you see the demand for arbitration anyhow changing? And do you expect any changes in the nearest future?
2020 has been an all-time record year for the FAI. We have so far, in late November, had 91 new requests for arbitration, whereas the previous record was 80 for the whole year. So at least the demand is not diminishing, I would say. I don't think, however, that much of the increase in demand is due to COVID-19, as there are only a few cases which clearly indicate the connection. Many people say that the flood of cases is yet to come, but I guess we will see. In any event, we are motivated to grow and develop our role in the market, but obviously no one wants to grow due to the difficulties that businesses face in these difficult times.
Well, congratulations on growing in spite of difficult times and not because of them. Turning to the details of arbitration process, could you enlighten us a bit more on what institution takes into consideration when appointing arbitrators? Are there some sort of internal guidelines that help to keep the high standard towards the arbitrators?
At the FAI, the board always has an open discussion on potential candidates for each case. I think factors such as experience and legal and business sector expertise are obvious. It could be said that the main rule that the FAI board applies is to think whom the parties themselves would appoint, having the knowledge that the board has about the market and about the case at hand. So the constructed expectations of the parties are of great importance.
Santtu, let's dive a little bit more into the internal processes of the institution. Does FAI keep an ear to the ground with the arbitration proceedings after the file is transmitted to the tribunal?
We do keep an ear to the ground in many ways, but we're not copied in the exchange of messages between the parties and the tribunal. Our instruments are primarily procedural timetable, arbitrators' duty to report new claims and changes relevant for the advance on costs, and finally, monitoring the time limit for final awards. According to the FAI rules, the arbitral tribunal shall arrange a case management conference with the parties as soon as possible, in principle within 21 days after receiving the case file from the institute. After the case management conference, the tribunal shall establish a procedural timetable and communicate it to the FAI without delay. The same goes for any modifications to the procedural timetable in course of the proceedings. If a counterclaim or a set-off claim is raised after the transmission of the case file to the tribunal, it shall promptly inform the institute and a filing fee has to be paid. The tribunal also shall promptly inform the FAI of any changes that may affect the amount of the advance on costs, such as any fluctuations in the amount of dispute due to new or increased claims. According to the FAI rules, the time limit for rendering the final award is 9 months in regular arbitration and 3 months in expedited arbitration. The Institute monitors the time limit and, if necessary, reminds the tribunal of it.
It sounds that you really take good care of the arbitrators. But perhaps the question that is interesting to young professionals is, how about young arbitrators? Is there any special approach for them, and how you involve them in the proceedings?
The FAI involves young arbitration professionals in many ways. We run a specialization program for arbitration lawyers, which is completed while working for 2 years as a case manager at the Institute. In addition to that, we have a 6-month part-time trainee program. The FAI actively cooperates with the YACF, Young Arbitration Club Finland, and of course sponsors the Vismut. The FAI also is annually organizing the Finnish Arbitration Academy, which is a 2-month education program specifically focused on the FAI arbitrations. The FAI appoints young arbitrators when they are the best option for the case at hand. That's the general rule. This is often true as there are many extremely talented young professionals who are willing to work very hard, even if the case is not the biggest and the fee not the highest.
And the young arbitration professional is probably somebody aged 50, given the average age of the world's elite arbitration specialists like Gary Bourne or Emmanuel Gallert and others. So Elvis will still run a chance. I'm
very happy with this definition.
Moving forward, the new trend among arbitration institutions can be spotted, which is an appellate procedure in the rules. For instance, JAMS has optional arbitration appeal procedures. European Court of Arbitration has as well. So what are your thoughts on such procedure, and do you consider implementing it into your rules?
We have no such plans at the FAI. Finality is one of the key advantages of arbitration. And even though finality is, as such, has very little intrinsic value, there is a very direct link to duration. I believe that the end customers value time, and thus we put emphasis on all the factors supporting accuracy in the first and final round, rather than offer appeal.
This is a flawless logical reasoning, which I can't challenge. Appellate procedure would make arbitration more similar to litigation in national courts, correct? So going forward, what would you say about the enforceability of the awards issued by the Finland Arbitration Institute? Do you collect any feedback about that?
Generally, enforceability is not a problem with the FAI awards, and not a problem in Finland either. The first and most important stage of monitoring and collecting feedback is studying and discussing the award at the FAI board after the award has been rendered.
Santtu, thank you for the insights and of the internal processes of the institution. Santtu, we are very grateful for your time, but we have one last question, a more subjective one. What is your best advice to attorneys representing clients in arbitration proceedings?
I'm afraid I might sound like a difficult person to interview, but I do not think I'm in the position to advise arbitrators or counsel. I feel it should be the other way around. I want to listen and I want to learn how we can do better. But on general level, I think we all, arbitrators, counsel, and the Institute, should stay humble, feel the responsibility that we have to our customers, and to remember our role as part of the system providing legal protection and conflict resolution for businesses.
Santtu, thank you very much for this interview. It was our great pleasure. Dear friends, we were here today with Santtu Turunen, Secretary General of Finland Arbitration Institute, Master of Laws, Vismont enthusiast, and an excellent company to what we all have just been witnesses. Thank you for staying with us, and goodbye.